I'm Drew Stevenson, and this is a lecture for my professional responsibility class about ABA Model Rule 2.4, lawyer serving as a third-party neutral. Now, this is a lightly tested rule on the MPRE. You might have one or two questions about it. There are questions on my final exam about this rule, and it's one of our simplest rules. So let's take a look. Section A is basically a definition rule or a classification rule. A lawyer serves as a third-party neutral when the lawyer assists two or more persons who are not clients, and I added the bold type here, persons who are not clients of the lawyer to reach a resolution of a dispute or other matter that has arisen between them. In other words, when lawyers serve as mediators or other types of third-party neutrals, the parties are not your client and you are not their lawyer. And this has a lot of implications for things like attorney-client privilege and whether the other ethical rules about duties to a client apply. It could even have implications for liability for legal malpractice, because remember, we're saying is part of the rule, they're not your clients, you're not their lawyer if you are serving in this third-party neutral role. So Section A continues. Service as a third-party neutral may include service as an arbitrator, a mediator, or in such other capacity as will enable the lawyer to assist the parties to resolve the matter. And so the most common type of third-party neutrals are, in fact, mediators and arbitrators. But sometimes lawyers are brought in by parties in an even less formal role, maybe as to moderate or facilitate a discussion, or as sort of finders or matchmakers between investors and venture capitalists and entrepreneurs, or between buyers and sellers of businesses. Now, keep in mind, this is very important. If you are being a mediator or being an arbitrator, there's separate codes of ethics for mediators and arbitrators that are going to apply to you that we don't cover in my professional responsibility course and are not tested on the MPRE. But if 2.4 applies to what you're doing, there's probably another code of ethics that does also apply to what you're doing. So Section B continues. A lawyer serving as a third-party neutral shall inform unrepresented parties that the lawyer is not representing them. So this is the conduct part of the rule, and the part of the rule that requires something, and it's pretty simple. It's a duty to inform. And this could be as simple as putting it in writing and handing each of the parties a statement that says, I am a third-party neutral. I'm being neutral here to facilitate the discussion or resolution of this dispute. I am not representing you or looking out for your interests. You're not my clients, and so forth. Now, notice here that from a textual standpoint, it says unrepresented parties. You have a duty to inform them. Sometimes the parties that hire a mediator or arbitrator already have a lawyer. And if they have a lawyer, we presume they know who their lawyer is, or their lawyer can tell them who's the lawyer and what your role is. So the duty here, and this is the whole, in terms of conduct or duties, this is the only duty part of 2.4, is a duty to inform unrepresented parties that you are not their lawyer and they are not your client. Now, 2.4 continues in Section B. When the lawyer knows or reasonably should know that a party does not understand the lawyer's role in the matter, the lawyer shall explain the difference between the lawyer's role as a third-party neutral and a lawyer's role as one who represents a client. And so, in other words, there's sort of a ratcheted up duty that's an affirmative duty to clear up misunderstandings if there's a misunderstanding that's apparent or it becomes obvious to you. And this part of the conduct rule of 2.4b doesn't specify represented or unrepresented. So even if a represented party seems to really misunderstand your role, then you have an affirmative duty to clarify and explain in detail what's going on and to try to clear up the misunderstanding. So let's look at the comments. The first two comments really just restate the rule or go over points I've already made. So I want to focus on a couple of points made in comment 3. Unrepresented parties present a higher risk of confusion. And you should probably just assume that if one or more of the parties don't have their own lawyer, that an explanation of your role is going to be necessary. And then the comment adds, this is particularly true for people who are unfamiliar with this process or going through mediation or arbitration for the first time. If this is someone who hires mediators all the time, then they probably get it and they know what the role of the mediator is. But first timers, we're very concerned that there's a high risk of misunderstanding. And similarly, be sure to explain the inapplicability of attorney-client privilege and work product doctrine. Sometimes parties may understand that you're neutral in terms of loyalty, that you're not fighting for one side or the other or advocating, but they don't really understand that the conversations themselves are not privileged. They're not going to be covered. Why? You already explained to them that they're not your client, you're not their lawyer. So the conversations may not be privileged. And that means if talks break down and litigation ensues, it's possible that you could be forced during discovery to disclose what was said in different conversations, or to turn over documents that you prepared for the parties as part of this mediation or arbitration. And that's something that a lot of parties are not going to understand or just assume, and you should probably assume you're going to have to explain to them. Comments 4 and 5 really just talk about some of the other rules. Now remember that a lot of the rules that pertain to ethical duties to clients are not going to apply because these people aren't your clients. But here's a few. In comments 4 and 5, it mentions that Rule 1.12 will apply if later on you decide to represent one of these parties, either in litigation over the matter or consummating the transaction. And 4.1, which is a rule about truthfulness to other parties, is still going to apply, even though these parties are not your clients. And 3.3 could apply when you are doing this before a tribunal. So if this is court-supervised mediation or arbitration or court-ordered mediation, even though you're not there representing a client or advocating for one of the parties, you still have a duty of candor to the judge or to the tribunal in the case. Keep that in mind. Okay, here's a review question to see if you've been paying attention. The partners in an accounting firm decide to split up and dissolve the partnership. So they agree to hire an attorney to mediate between them and facilitate their negotiations. Does that attorney have a duty to inform them that he is not representing any of them? Yes or no? Hopefully you know the answer to that. It's supposed to be an easy question. If you don't, or you're stuck on it, you should probably rewatch the video. You might not have been paying attention. And that concludes our lecture about ABA Model Rule 2.4.